Session. I'd like to welcome our witnesses here today, Bríd Smith, Colin O'Gogan and Matt Kelly. You're all very welcome. Before I invite guests to make their presentation, I just want to read a note in relation to privilege. I'll then invite you to make your presentations, and members will have a number of questions for you after that. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter, and you continue to so do, you're entitled thereafter only to a qualified privilege in respect of your evidence. You're directed that only evidence connected with the subject matter of these proceedings is to be given, and you're asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. And members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the House or an official, either by name or in such a way as to make him or her identifiable. Once again, colleagues, if you have mobile phones, you might either turn them off or to flight mode. Apart from interfering with the proceedings of the meeting, they actually interfere with the recording and transmission of it. So at this stage, I'll hand over to the witnesses. I understand, Mr. Butler, you're starting. You can do them in any order, and then we'll go to colleagues for questions. Right.
Thank you. First of all, I'd like to say I'm standing in for our chairman. I'm here representing the RTE Retired Staff Association, and unfortunately, our chairperson, Mr. Tony O'Connor, unfortunately, and he sends his apologies. Firstly, I want to express our sincere gratitude to this Oireachtas Pensions Committee for taking the time and interest to meet with us here today. We're a group of retired staff associations from a number of the semi-state organisations. We are people who devoted our entire working lives providing infrastructural services for this state. We represent a great number of people who provided these services for the benefit of this country. However, though we are a large group of retirees, semi-state pensioners do not have any recognised mechanism or organisation to deal with our concerns, our grievances with our former employees. In fact, we're locked out of everything really, all the machinery of this state. A retired semi-state pensioner is set adrift once they walk out of that door. The Pensions Authority doesn't deal with complaints from pensioner organisations, nor does the Pensions Ombudsman, nor does the Industrial Relations or trustees, or the trustees from our own pension fund. Obviously, legal remedies are totally cost prohibitive for pensioners. As this situation is currently, semi-state pensioners have no avenue for representation or access to any kind of arbitration. Hence, we now believe that this must now be corrected to seek a voice for our members at the negotiating table and the facilities for arbitration. Some of our key facts. It is not commonly understood that there are a few exceptions, that most semi-state or state organisation pensioners do not qualify for any old age pension, and none of the benefits associated with it, dental, optical or oral benefits. And certainly in the case of RTE, we don't benefit from any of these things. We were not allowed, in fact, we were prohibited from paying a full PRSI stamp. And there's some kind of myth out there that RTE pensioners have some kind of gold-plated pensions. The reality is that 1/5 of our pensioners are on an income of $12,000 a year. We have not received 1 penny in our pensions since 2005. In the same period, contributory old age pension recipients have had their pension increases from €179 to €248. That's an increase of 38.5%. They also receive a double payment in the Christmas period of 2017, and they're due another payment, double payment, this Christmas 2018. In this same period, our pension has decreased by 2.5%, arising from the government levy. A levy that's imposed on us for the rest of our lives. But coupled with this, the inflation, the CPI, has increased by 14% since 2005. So we have endured a lost value in our money of 16.5% since 2005. That's how much we have lost in the value of our pensions. Earlier this year, RT Pension Scheme actuary had provided for a 2.25 increase following the actuarial valuations, solvency, and providing for the minimum funding standards. Despite these hurdles being met, we have not received €1 increase. Our association have made numerous representations on behalf of our members to RTE, and nothing, we haven't heard anything back. We feel that clarity is now required as to who is responsible for public sector state company pensions. Is it the companies or the state? There are variations in all these schemes into how they're governed and in how much oversight is involved by government departments. In our case, we have the Department of Finance and the Department of Communications. We need absolute guarantees that our concerns are going to be addressed in this forthcoming amendment to the Pensions Bill. Looking forward to the future, our members must have the resources to feed, to clothe, to stay warm, and to be able to meet their health needs as they progress through their older years. That's my statement.
Thank you very much. Mr. O'Gogan.
Right,
please.
Joan Collins, pensioner as Bordamona. I'm a pensioner from Bordamona and a representative of the Retirement Association. In the general scheme of the Social Welfare and Pension Bill 2017, as published on the 9th of May 2017, under heading 12, minimum notice for ceasing contributions, and head 13, determination of schedule of contributions, provision has made for some but not sufficient protection for pensioners from employee sponsors of defined benefit pension schemes who intend to cease contributions to the scheme. Under Head 12, provisions of Head Point 5, where it refers to funding proposal, references that. It proposes that the sponsoring employer continue paying to contribute the rate as per the terms of the funding proposal during the 12-month period. And under Head 13.2, it also states that the amount determined by the board in subsection 1 shall be deemed as a debt due from the employer concerned to the trustees of the scheme and may be so recovered by the trustees in any court of competent jurisdiction. The Social Welfare, Pensions and Civil Registration Bill number 94 of 2017, as published on the 6th of July 2017, had none of the above. In fact, 12 and 13 heads were excluded. Instead, it had only 2 amendments to the Provisions Act, to the Pensions Act 1990 and Part 3 concerning timing. I'd like to bring to the committee's attention some facts in relation to the semi-state defined benefit schemes, semi-state companies defined benefit pension schemes. Number 1, pension scheme membership was compulsory on a condition of employment. And in looking at my own documentation, my job offer letter from Bordamona on the 19th of August 1974, page 2, the board has in operation a general employees superannuation and widows and orphans pension scheme, membership of which is compulsory. I just want to put that on the record there. The next thing then is that the scheme trustees are appointed by the company and its board, who also have the right to approve trustees who are nominated by members, and in some cases members have a right to nominate trustees. The company board approvals are required for trustee decisions. Example, pension increases, as has been mentioned by Bríd there, appointment of investment managers and investment strategies. The shareholder, through its company board, has significant influence and control on defined benefit schemes, and this must be aligned with its responsibility and accountability to those schemes. Referring then to under Clause 5, provisions of Head under Head 12 in the draft head as published in May 2017, and the reference to funding proposals. The draft bill proposes that the company/sponsoring employer continue paying the contribution rate as per the terms of the funding proposal during the 12-month period. This, in line with the company responsibility and accountability to the scheme, which I referred to earlier, must also reflect the requirement to make good the sponsoring employer's remaining balance of the funding proposal, and that this becomes a debt on the sponsoring employer. The ranking order of this debt should be reflective of when the debt was incurred, i.e. the date of the agreement on the funding proposal. The rationale for this: in all schemes, and especially in schemes where both the sponsoring employer and scheme members both contribute to fund deficit resolution via funding proposal, the scheme member share is fully committed and provided for, as scheme liability is immediately reduced via the implementation of pension payment reductions, whereas the sponsoring employer's contribution is made on a phased basis of up to 10 years, as may be set out in the terms of the funding proposal. So in summary of my point here is, the sponsoring employer sets out the rules and controls of a DB scheme via the trust deed. They have total control on that. We ask the committee to ensure that this power is aligned with the sponsoring employer's responsibility and accountability to the scheme. A 12-month notice period of cessation of funding proposal contributions is not reflective of that responsibility or accountability.
Thank you very much, Mr. O'Gogan. Mr. Kelly.
Buchas muir dit agus dana trí buil den cóchaiste atá anseo inniu as ochtéisteachlein. I would like to address the committee about the minimum funding standard and its effect on the pension freeze that, in the case of many semi-states and including ESB pensioners, have had a pension freeze for 10 years. There's a triple lock on pension increases to be considered. In some cases, as well as the triple lock, there is any proposed increase is subject to employer approval as well. These locks are scheme solvency, the minimum funding standard, and actuarial opinion and assumptions. This has resulted in semi-state company pensions having a freeze on pensions, as I said, for a 10-year period, which is a very significant portion of a pensioner's remaining lifetime, while being denied any compensation for a cumulative price index increase over the period. And indeed, what affects pensioners is the consumer pensioner price increase, which would be even greater. We don't buy Ferraris. So under scheme solvency has been impacted by the pension levy, which has resulted in semi-state pensioners burdened with a levy on their pensions for life. And should the pensioner predecease a spouse, it must be remembered that that levy will apply to the spouse's reduced pension, half pension of what the pensioner had for the spouse's lifetime. The minimum funding standard, as applied in Ireland, needs greater flexibility in reserve calculations and on quoted costs of annuities, which can overstate the costs of annuity purchase. This has been stated by the Minister, but we are waiting for the Minister to effect any amendments to the bill going through the Dáil at the moment. In fact, I am amazed that the bill as it stands at the moment has only 2 items from mentioned on pensions, and they are timing items. There is absolutely nothing else there that was published in the general scheme. I cannot understand why that has happened. The ability of the state to apply levies by means of stamp duties or similar charges to pension funds, and these pension funds, we must remember, are the private property of scheme members. It's legal but morally indefensible. It would not encourage those who may be auto-enrolled in future proposed state employer/employee pension schemes to remain in them if the funds are liable to be levied in times of financial stress. Provision in actuarial assumptions for annual percentage increases in pensions, which are known that they will not be paid, create even further liabilities on pension funds and push the funds further into a parent deficit. Semi-state workers employed before 1995 in many state organisations differ from other employees in that a condition of employment was obligatory membership of the company pension scheme and exclusion from qualification for a state contributory pension. Therefore, it is implicit that the first-tier benefits available to state contributory pensions are included in semi-state employee and pensioner benefits. The pension freeze has ignored the fact that since the pension freeze started in 2008, an approximate 9% increase in state contributory pensions took place during the pension freeze period. When I joined ESB, there was a pension promise. The pension promise was that pensions would reflect the salary of the job you left. This pension promise implicit in the state pension schemes has not been honoured. And during the last 10 years, and we ask you that you work to give legal effect to the pension promise and to vindicate the legitimate expectations of pensioners. All of the factors above have impacted to the detriment of semi-state pensioners and need to be addressed in amendments to the bill. The omissions, as I said, mentioned in the general scheme are of great concern to pensioners, as is the fact that semi-state companies and employer organisations have lobbied to have certain provisions of the general scheme removed or not included in the bill. In summary, the proposed amendments the Minister said were intended to be reduced at committee stage allow an employer to walk away after a 12-month notification period with a possible funding obligation by the employer to be determined by the Pensions Authority. These are insufficient to provide adequate protection from pensioners because an employer after 12 months can walk away and abandon the pension scheme. We urge the committee to make efforts to have these protections included in the bill. And as a summary of what was said today, I have 7 points here. Legislation is necessary to enable representation and arbitration for pensioners. We've been everywhere, as Mairead has said. We have nowhere to go, and representation is no good unless we have arbitration. Number 2, definition of the ultimate responsibility for funding deficits in the public sector companies is needed. Flexibility in the minimum funding standards must be provided to avoid overstatement of liabilities in the pension funds, which results in the pension freeze. The extension of employer debt should include balance of funding proposals beyond a walk-away period of 12 months. Legal effect must be given to the pension promise of the legitimate expectations of pensioners, and a constitutional prohibition on the imposition of levies or similar charges on pension funds legitimately set up under the legislation is necessary for the pension auto-enrolment proposal. Tomorrow we are having a constitutional referendum on blasphemy. That doesn't affect a lot of people. This affects hundreds of thousands of semi-state pensioners. I know there was a constitutional proposal I think it was the 35th Amendment. I don't know where that has gone. Perhaps Deputy O'Dea can comment on that. And finally, we need the inclusion of pensioners' representative organisations in consultations to identify funding standard reform options. That's needed to provide balance and equity. One of the big problems is that wherever we go, organisations, state agencies will say, we will talk to individual pensioners. Individual pensioners don't have the ability to represent the entire body of pensioners. The representation by organisations representing pensioners is absolutely necessary. We are facing IBEC, we are facing semi-state corporations. We can't be represented by individuals.
Thank you very much, Mr. Kelly. Just before I go to our colleagues for questions, one question, quick question. The 7 points that you've just read out and are they from your pension fund specifically, or are they collective?
They are collective.
They're from, okay. And secondly, I suppose just to clarify, you referred to the bill and you quite rightly say it was published in May 2017. Members of this committee will reflect and recall that prior to the publication the heads of the bill had been available and this committee dealt with them in pre-legislative scrutiny. We were as surprised probably as you that when the bill was published certain sections that we had seen at the pre-legislative point weren't in the bill, and certainly I spoke in the Dáil in July 2017, just before the summer recess, and the Minister quite clearly indicated that there would be substantial amendments brought forward at committee stage. This committee has written to the Minister, just to fill you in, on a number of occasions concerned with the time lapse in bringing forward those amendments, because, as I say, that's over a year ago, and we had anticipated, to be quite honest, that we, maybe wrongly, but the committee would have felt we would have been dealing with it the committee stage of the bill around this time last year. So the committee has been in correspondence with the Minister urging that this be dealt with. Now obviously the Minister hasn't brought those amendments forward, so we're familiar with the issue. And just to bring you to date, we had seen a number of amendments when the heads were published, which are number of heads, should I say, not amendments, but when the bill came forward they were missing, and as I say, we as a committee have been looking to see them since. And I suppose the final point I'd make is, generally speaking, while we work collaboratively as a committee, it's up then to individual members and parties to bring forward amendments at committee stage also. Deputy O'Dea.
Thanks, Chairman, and my apologies, my voice is slightly affected by the flu this morning, but I want to thank you all for coming in anyway and for the excellent presentation you've made. And I don't really have any questions. If you don't mind, I'd like to make a few comments on what has been said, because much of it is very familiar indeed. To start at the end there with Mr. Kelly's presentation, the position, you know, my view on the present minimum funding standard and the solvency, how solvency is calculated, etc., how pensions are calculated, are fairly well known. I think they're insane, quite frankly, and they bear no relationship whatsoever to reality. Now, in an earlier piece of legislation, as the Chairman will be aware, I had an amendment passed by the Dáil to require the Pensions Board to come up with an alternative system, or a number of alternative systems for us to look at. But seeing that legislation has been parked and is currently residing somewhere in the Bermuda Triangle, we don't know where we are on that, but we're going to continue to push for it, because I mean those rules, those accountancy type rules, are absolutely irrelevant and have resulted, as you rightly say, in many pension schemes, many defined benefit pension schemes being declared insolvent, when in reality they're not insolvent. The big thing here, of course, is access, lack of representation. I mean, it seems to me, I don't know what the total number of semi-state pensioners throughout the country is, but I imagine it's quite considerable. And I mean, it is at this stage in 2018, it's absolutely beyond bizarre that such a large group have actually no avenue to which to make a complaint. I mean, members of private pension schemes, they have access to the pensions ombudsman, they have access to various organs, but you have no access, and that's something that we will have to deal with in the forthcoming legislation if we ever get to see it. The Minister's been promising to bring it back now for over 14 months, but we will be pushing for it. And I think that there's no reason we will have a social welfare bill here to reflect the changes in the budget, but I don't see any reason why this legislation, which has lain in abeyance for so long, should be much longer delayed. Now, as the Chairman has rightly pointed out, and as you have recognised yourself, you had heads of a bill which we discussed here, and which included certain protections, protections which, in my view, weren't adequate. But then we had a bill, and they disappeared from the bill, but with a promise from the Minister that there would be substantial amendments to reflect the earlier heads. We're still waiting to see those, quite frankly, and they were based, the initial proposals were based to some extent on legislation which I introduced myself by way of private member's bill to provide substantial protections for people in defined benefit pension schemes. They weren't going to bring the pensions industry to its knees. They weren't going to cause the sky to fall in, because they were modelled largely on what has been done in the UK for defined benefit pension schemes. So they weren't extraordinarily radical, but they were a huge step forward on what we have in this country at the moment, which is virtually nothing. And talking about a 12-month period, or putting a charge on the assets of the company because of non-payments for a 12-month period, it's self-defeating nonsense, really. I mean, it doesn't achieve anything, and it may have unintended consequences which are quite the opposite to what it was intended to achieve in the first place, and that was all gone into in the debate. I mean, I find it absolutely extraordinary that despite the fact that you have no access to say, organisations like the Pensions Ombudsman or whatever, that in some cases, even in some cases where the actuaries have decided, or where the trustees have decided that you'd be entitled to a pension increase, that actually hasn't happened. The company in question, the employer, has been able to ignore that. I'm quite familiar, for example, they're not represented here today, but I'm quite familiar with the CIE situation, whereby there was an agreement back in 1994 where two loss-making two pension schemes which are heavily in deficit was amalgamated with a scheme that wasn't. And as a quid pro quo, the company undertook to pay pension increases to retired staff members as salaries increased, and that has not been honoured. That has not been honoured, despite the fact that in some cases the actuary has recommended it. It has not been honoured. And now I see here that even the trustees out in RTE have recommended a 2.5% pension increase. That's not being paid, which strikes me as a bit ironic, because I remember being out in RTE involved in a current affairs programme at the time of the controversy concerning independent newspapers, and I met a whole lot of journalists and producers and programme managers, etc., out there who were bursting with indignation at the carry-on of independent newspapers. And here we have a situation now where they're not prepared to pay a pension increase of 2.5%, recommended by their own trustees to their retired staff. So, there's a lot of hypocrisy in this country, and that's just another example of it. Anyway, look, the question of the levy, we put forward legislation to prevent governments of the future, of whatever persuasion, imposing levies. And as you rightly point out, the fact that a levy can still be imposed is a deterrent. It certainly will slow down the auto-enrolment process when it comes in, because people will be tempted to opt out, and you'll probably have a whole lot of them opting out if at some stage a levy is imposed. So there were some constitutional difficulties with that, genuine constitutional difficulties, and we have committed to resubmit it. And I hope we'll be able to get all those things done while this stall is still in existence. but we are certainly we're committed to that. So, but the immediate thing is amendments to protect people like yourselves and people in defined benefit pension schemes generally. Amendments to the forthcoming legislation, which is due here. It has been due for the last, as I say, 14 months. So we'll get a head start with drafting some of those amendments. And thank you for your suggestions. They will help us in the work we're doing already in drafting amendments to that. And you can rest assured we will have the appropriate amendments drafted. If there's anything else you want us to put in, or if you have any concrete suggestions apart from what you say here, send them on to us by all means. So, you know, we'll have our work done. We're just waiting for the Minister to reproduce the legislation so we can give effect to it.
Thank you, Deputy O'Dea. Senator Higgins.
Certainly, and thank you very much to all who've presented. I think this is, again, it's an issue, as the Chair described, which the committee have been pressing on and raising in our private session and corresponding on consistently for the last 2 years. For myself, I proposed amendments to the Social Welfare Bill back in December 2016. In relation, it was not to the semi-state, but to, I think it was in one of the newspaper chains at the time, and defined benefit schemes. And we were assured that speedy action would be taken. That's what we were promised, and indeed what we facilitated by moving our schedule as a committee in 2017, early 2017, when we sat and looked at the heads of bill, and it has, of course, gone into complete abeyance since. I think there's a lot of really very, very valid concerns, and there's also very serious questions that we need to look at, as I think was signalled by yourselves, in terms of any future auto-enrolment scheme as well. But I think the first thing, and just to give a very quick response on the 7, and then I'll come into what I think are the 2 core issues for me. I think there's very valid points in all of these. The one where I would have some concern is in respect of the question of a constitutional provision in respect of levies. I think there may be issues in respect of that, honestly. But I do think in terms of the other issues, I would strongly support them. What I think is really important to note is, in the case of these, of yourselves as employees, first of all, the question of representation is fundamental and key. I mean, this is part of a relationship that you have had, and a collective relationship. The measures that were secured or required were collectively done. It is a part of an ongoing relationship, and I really fundamentally believe, I worked with Oldham Boulder for many years, I fundamentally believe in the right to continue to organise and to continue to speak and represent yourselves collectively. I think that's fundamental in relationships with an organisation and a company, and I think it's certainly the divide and conquer approach which seems to be taken, whereby individuals have to individually fight and take cases, is not acceptable. There is a particular question in terms of semi-state bodies, because I think, as is pointed out very eloquently by yourselves, this is not a matter in which in many cases people have choice. It is not a provision which was there as an option in terms of persons. And I think that's the one thing I'd be cautious of when we talk about auto-enrolment schemes and so forth. They are supplementary pension schemes. But this, and what was offered in terms of the semi-states, this is your core pension. And in this case, this is the fundamental basics for your living the rest of your lives. It is the core. The option of engaging, for example, in many cases, I know not all, but in many cases, the option of engaging with a contributory state pension is not one that was available. When we have had presentations from the department, they've been very clear about the different purposes. The purposes of the contributory state pension, for example, to provide a minimum to ensure an adequacy of income. An adequacy, a core standard. It is not. The supplementary pension then is to increase the level of replacement income, for example. But that idea that you are entitled to have a fundamental security. This is not a speculative pension, it's not an additional supplementary. This is your security, and I think you are required to pay into it, and I absolutely think there needs to be a clear message in respect of, I think it is put in the heads of bill that then managed in terms of that this is a debt, and that there is and that it is something which is owed, and that there is a duty and responsibility in respect of, in terms of its delivery. I think we need to kind of be very clear there. So this question, I think this is where I'm worried is that not only is that there seems to be a slipping away, the idea that you can say, well, we have this debt, but it'll disappear after 12 months or we'll walk away, is just frankly completely unacceptable. You cannot, I mean, this is the core foundational contract of employment and contract that is made via the state and via its bodies, said bodies. I think that's absolutely fundamental and should be fought tooth, it can be fought tooth and nail. But I want to just go as well as that question of that the responsibility can not be stepped away from. There is that question of where we say risk and duty, the question of risk, and I'm very, very concerned in particular by the correspondence we've received in terms of the question I think that our national broadcaster are looking at the moment at a contract in respect of advisors to look at mitigating risks. And again, the risks that they are mitigating are not the risks that there may be former employees who have an inadequate replacement income or inadequate income in terms of the fundamentals that they need to plan the rest of their lives and to live well. The risks seem to be risks to the organisation in terms of regulatory, operational, legislative or legal risks. I think it's very, very, very clear and very important. And this was a big debate when we came to the supplementary income. The question, where does risk sit? Are we going to have risk placed on the individual? Is risk going to, where does the risk and where does the guarantee sit? From my perspective, in respect of the proposed supplementary pension system, there has to be a fundamental level whereby the risk sits with the state who is proposing the scheme or with the company in the case of if a pension company is contracted in terms of the Universal Supplementary Retirement Savings Scheme. But you cannot have a situation where risk is spread out to the individuals and in the end, given what we saw in 2008 where we had, for example, private pension schemes that lost 38% of value, that individuals took the hit. I think that's fundamental there, but I would just say that's a fundamental argument on the supplementary scheme, but it is much more serious for yourself because this is core pension, this is first-tier pension. This is first-tier pension. The supplementary is a second-tier pension. So I just want to kind of underscore that because I think we could get lost, and I very much support you in that. I would really appreciate just your sense in terms of as well of your experience in terms of when you were, as persons, paying into a pension, making the choices, your expectations. What brought you, when you were putting them in, what plans in terms of, not for you as individuals, I mean, but for those that you're representing, in terms of the legitimate expectations. I imagine that very few of you are saying, I'm putting this in and I'm hoping, you know, stocks go up and I managed to get a fabulous dividend. I think people went in with the idea that they were planning for the long term. And just if you could kind of reflect that. And a very last question here. Yes, if you wanted to elaborate on that concern around the idea that there's a very large, I think it's 500,000 tender contract going out at the moment in terms of the mitigation of risks and responsibility, and if there was anybody in terms of RTE who wished to comment on that. And thank you very much. I had one other point, but I've lost it in my discussion. So we might get back to
you again, Senator. Would any of our witnesses like to comment on the points? Yeah, sure.
Yeah. Just short questions. I mean, I'm new on the committee, but I know when I first came on, the pensions time bomb was happening in Irish Life. And interestingly, Irish Life actually deal with defined benefit pension schemes for hundreds of other companies, but the employees there were having the DB benefit scheme taken from them. And the one thing we could say to them was, in the heads of bill, there's a mechanism there that might offer you some protection. And then, like the other deputies and senators have said, it came back to us, the heads of bill, the mechanisms removed. So it's quite a serious challenge, and I appreciate very much you coming here, but I have a couple of questions about the collective nature of how you're representing each other and the groups that are around you. There's 3 organisations, semi-state organisations here, but do you represent others as well? We do. Yeah.
We basically, this has been going on. We've been meeting for the last number of months, really. We ourselves in RTE started to look at the whole situation. We knew our pensions were really decreasing. You know, we weren't getting the same, value in our pensions, and there were a lot of concern. So we contacted other pension organisations, like-minded people who are in the exact same situation as ourselves. So we're represented, the ESB are represented, Bord na Móna are represented, Bord Gáis, CIE, Aircom and the airline staff. We're all...
And my second question then about that is that you say most are affected by it. So is there a cohort of, are you a certain grade that are affected?
No. From what we understand, there were certain semi-states or state organisations that were allowed both pensions. They were allowed to pay their A stamp and they were allowed to pay their D stamp. However, in RTE, you certainly weren't allowed. You were totally prohibited from paying an A stamp. And I think the same applies to the ESB and a number of other ones. And of course, you didn't have any of the auxiliary benefits of the A stamp. So the only...
Because I asked, my father was a bus driver and he got the OAP.
Yeah.
And a tiny little pension from CIE. But I think the grades above him, inspectors and all, didn't.
Yeah, nobody in RTE
But it's not a grade thing, is it?
No, it's not.
Okay.
It's a general thing. So it affects everybody in RTE.
Okay.
Everybody who's on defined benefit, defined pensions.
And then just to comment on your presentations, there's a number of things that really jump out, like 1/5 of our pensioners are on 12 grand a year. You know, stuff, the stats are very startling and indicate a level of poverty, income poverty that...
People really don't realise. No. You know, as I said in my presentation, there is a myth out there, particularly maybe from RT, because they read headlines in the papers, you know, these huge salaries, huge... But you know what? 80–90% of the ordinary working force that are going into that organisation every day, be they technical, be they whatever, clerical, be they people, I mean, I myself worked in the programme area, like we're on very moderate salaries. And, you know, we're not on any kind of gold-plated pensions or anything but, and it is true that 1/5 of our pensioners are on pensions as low as 12,000, which is something that...
Mr. Kelly said something quite startling, which is that having a freeze on your pension for 10 years, it's a big chunk of your life when you're a pensioner. You haven't got that many 10 years is left, you know.
Don't tell him that.
No,
Well, it doesn't happen, like, do you know what I mean?
Mr. Kelly, you wanted to comment there.
Yes.
Just Mr. Kelly.
Just on the gold-plated pensions, that's not true. They were brass-plated pensions, but we haven't had a brass farthing for 10 years. We also have RASA, the Retired Aviation Pensioners Association, associated with us. And in 2014, just before the cuts, their average pension was 16k approximately. And after cuts, the average pension there is 14k. In the case of ESB, the average pension is 26k. Now, we must remember, with all these averages, they are averages of those above and those below. And those below are suffering hardship. They are finding it difficult to live. They are having to cut their private pensions, their private medical insurance. They're really struggling at this stage because they are not even matching the first tier safety net that Senator Higgins has spoken about. It's a very serious problem for semi-state pensioners, and the state is not showing any appreciation of the 40 years we have spent working for the infrastructure, to provide the infrastructure for this state.
Thank you, Mr. Kelly. It's Deputy Smith, yes?
Whoever said there that there's been lobbying on behalf of the companies and the employers' organisation, I think that's written all over this. But we need to start lobbying, or you need to. I hate to separate myself from you, but the workers, the pensioners, need to start lobbying stronger, I believe, and, you know, making your voice heard, because these are really quite stark statistics and facts. And I would like to echo what Deputy O'Dea said there at the end, which is, if you have any concrete suggestions about amendments and stuff, please send them on to us, and be very happy to push your case.
Senator, Senator Higgins, I'll come back to all of you.
It's very specific. So one sentence, which is just to say that I think that question that people were prohibited from getting that safety net of the below the first tier. But then I think those who were on high incomes, of course, they have the private pension tax relief and those schemes. And I think that's where the very high earners in any organisation are very much being subsidised in terms of the private pension tax relief system we have, and we've discussed that before in the House. Whereas the guarantee that most people want, which is to be able to pay into a guaranteed safety net, that one is away. So it's interesting that I think within that core, the very high earners will go one way and the others. But my specific question was just, and it was in relation to Mr Kelly's presentation, but others may have comments, in terms of when we try to grapple with this bill, when we get it back in terms of the block, that triple lock system that is blocked in terms of increases, what measures you think specifically? Is it around pushing on transparency around how that is exercised? Is it around ensuring that employer approval is removed completely from being a so that this is the scheme solvency, minimum funding standard and actuarial opinion and assumptions. So as I say, there's a lot of there's a lot of hoops to jump through before an increase happens. Is it around removing that extra hoop, which is and employer approval? Is that the first thing that we should move? Or is it around in transparency? Or where do you see of those three hoops? I'm more like thinking of that navigation, how we can maybe try to make sure that it is not functioning as it is now as an effective block.
Mr. Kelly.
Yes. I would think that what this committee can do most effectively is to tackle the minimum funding standard. The minimum funding standard is there to be amended in the bill currently going through the Dáil. As Dr. O'Dea said, minimum funding standard affects the liabilities of pension schemes. The liabilities of pension schemes are used as blocks. Now, the other point about actuarial opinion, we would see actuarial opinion where assumptions are made on facts. Assumptions are made when you don't know what's going to happen, but when assumptions are made in the full knowledge that there's a pension freeze for at least 10 years going, and that puts an extra liability, something like 700 million extra, on the ESB pension fund, which is the one I'm familiar with. And indeed, actuarial opinion decided last year that we in ESB are going to live longer than everybody else in the country, and thereby lumped a huge extra liability of hundreds of millions extra into the pension fund. I don't know. It has been reduced this year. I don't know why. Perhaps because we have highlighted the problem. We feel that employers have too big an influence on allegedly independent boards of trustees. The boards of trustees are largely appointed by the people appointed by the employers are generally very highly placed individuals within the companies, and whereas the trustees are very assiduous in not revealing information to the members, we don't know how much information goes back to the employers. And in fact, this is something that the committee might look at in relation to the IORP2 directive that must be in law in this state by the 13th of January this year. I don't know whether it is proposed to implement the IORP2 directive via the current pensions bill, or where is it going to come from? I haven't seen it mentioned anywhere, but again, the state is going to be in breach of an EU directive if it is not in legislation by mid-January in the coming year. 13th of January is the actual date. Thank you.
I'll afford all of you an opportunity. I just want to make some general comments. From the committee's point of view, the presentations you made were certainly eye-opening. I think most of us would have been unaware of the lower-end pensions that you refer to, where people are pensioners on pensions, particularly, Mairead, you indicated 20% less than 12,000, where people are on pensions less than the state pension, you know, from semi-state bodies. I think that was an eye-opener. And Mr. Kelly, you came back then and gave averages from others. That type of information has been very useful to the committee, because I think it's not something that is we would generally be aware of. The second thing that I suppose the committee were concerned about is the fact of the lack of access and information and the difficulty. And as you indicated, yes, you can go the legal route if you have very deep pockets, and it is not, you know, it's not the route that most people can access. So your presentations have been very helpful and informative. And in terms of the minimum funding standard and so forth, I think Deputy O'Dea has referred to it in quite a level of detail. And colleagues have indicated from their own point of view, because that's the way legislation works, that at committee stage of a bill they would be prepared to make those amendments or bring forward amendments. And I suppose it's worth noting that the more consensus there is, the greater the opportunity of the amendments being successful. So I think that's quite important. From your point of view, as a committee, you have specifically set out on the last page, Mr. Kelly, you circulated with the 7 headings. It would be useful from our point of view to understand the government's response to those 7 issues, and we will correspond with the Minister directly. We will keep you informed. I'm not suggesting she will be supportive or otherwise. That's not the first. It's the government's position or the Minister's position on those points. I think would be worth having. So we will correspond with you when we get those responses to keep you in the picture. Are there any colleagues who, Deputy O'Dea?
Yes. Have you any idea what sort of numbers you're representing, or how many?
In RT, we're representing just over 1,500 people who are on defined benefit pension.
1,500?
Yeah, that's what we're representing in RT.
ESB?
9,000.
More than one would be in excess of 2,000.
I would just like to add to that I know that some of our members are really struggling. They are really struggling. You know, if there's an illness, if there's any extra things, they just don't have the money. And, you know, and it has been frustrating from us, because the trustees of our own, we can't talk to the trustees, we can't, as we have said, all the other machineries of the state, we've been completely locked out. We've had no avenue to negotiate, to get representation, to get arbitration, and that is crucial for us at this stage. It's a really important point that we need to be able to talk to people.
Mr. Kelly?
Yes. Just to follow up on what Mairead has said there, I'll just give you a listing of where we've been and where we've had no representation, or where we were refused representation. The Equality Tribunal will deal with equality only, and it will only deal with pensioners for a 12-month period after they have left employment. We would much rather be regarded as former employees than as pensioners. The Ombudsman will only deal with individuals. I've made that point, that individuals need their organisations to represent them. In the industrial relations procedures provides protection for workers, current workers, and trade unions only. They will not listen to us. The Pensions Authority will not listen to pensioners' organisations. Legal remedies, as has been mentioned, are absolutely cost prohibitive, because any time we tackle the corporate state companies, they throw every weapon, legal weapon, that's available at us. It's an unequal fight. We have not got the resources to legally challenge the companies. So that's about it. I would go back again to the minimum funding standard. Minimum funding standard is torpedoing our pension funds and torpedoing any hope we have of an increase for whatever time is left to us.
Deputy O'Dea, had you concluded?
Yeah.
Okay. Senator Higgins or Deputy Smith, have either of you concluding remarks?
That was very useful.
I would just simply say that fundamental question of representation is one we will definitely need to pursue as well. As individuals, I think it's vital that you've represented your colleagues and your former colleagues so very well today, and I think that you should be afforded that opportunity in every other remit.
Thank you, Senator Higgins. Ms De Butler or Mr O'Gogan or Mr Kelly, any comments? Or
No, just on the minimum funding standard, and Matt alluded to it there, and I think Senator Higgins alluded to de-risking in RT and that, you know. Okay, if you de-risk and you move to equities, your risk reserve is reduced, which means your liabilities are reduced. But we all know that equities are returning very little at the moment, and as such, as Matt says, that people haven't had a pension increase in 10 years. What I would say is, if it keeps going the way it is, there'll never be a pension increase. And that's a huge concern, and that's why the minimum funding standard review has to be called into question, and quickly.
I suppose I'd just like to bring just a statement that RTE wrote to the government, and they said, increasing employer risk is likely to lead to unintended consequences for pension schemes, as employers, in assessing the risk, may be less likely to exercise discretion where they have it, such as in the case of discretionary pension increases, and may also consider means of curtailing the risk. You know, I mean, we know what they're thinking about, you know. So they feel that they have all the discretionary means to curtail any increases due to people who paid into a pension. This is a deferred pension salary for us. We all paid into this pension fund. It was a private fund that we actually paid into. So they're our assets.
Thank you very much. Ms De Butler, Mr O'Gogan and Mr Kelly, thank you for your attendance and presentations today. As I did indicate to you, we will stay in correspondence. We're anxious as a committee that this bill come back before us. I specifically said the 7 points you made, I will get the Minister's response to those, and you've heard from colleagues here who are prepared to bring forward various amendments at the committee stage of the bill. So thank you for your attendance, but we will be in contact over the coming weeks as we get those replies. And if there's anything further that emerges from your point of view in terms of drafting of amendments, please feel free to stay in contact with this committee. Colleagues, we will adjourn, and we will stand adjourned until 10 a.m. on Thursday, the 8th of November. Thank you.